library attorney. And this is the first of the two parts. This is a presentation on why a library would need a labor attorney. We are very fortunate tonight that Wellforce should tell you the program is sponsored by the Buckles Trustee Development Committee. I'm Tom Madrew, and I'm the co-chair of that committee. And Caitlin Hull is my co-chair. And we're co-sponsoring this with the Buckles Library Administration Management and Personnel Committee. And we're very happy to have them co-sponsor with us. Their leaders are Tara Cooper and Jenny Pooh. Tonight we have two very esteemed lawyers with us who will make their presentations in a minute. We have Adam Abramson, who is a partner with Cleary, Giacobbe, Alfieri, Jacobs. He is a general counsel and has been working with libraries for over 18 years. And Douglas Zucker is here. He is a partner with the Weiner Law Group, and he too is a labor and employee attorney, a general counsel, and he has been representing public libraries for over 30 years, and actually now has 26 public libraries that he is representing. We will be hearing from them in a moment, and we're very, very thrilled to have them with us. However, before we start, I would just like a couple of administrative things that if you do have questions during the presentation, please put them in the chat box. A couple of us will be monitoring them. And when it becomes appropriate, we will pass those on to Mr. Zucker and Mr. Abramson. Also, feel free to turn your cameras off, but please, or on, but please mute yourselves if you're not already muted. So enough of that. Now I'd like to start. We also are very fortunate to have Adele Puccio, the president of the Buckles Group. She is the director in Fairlawn, and we have Dave Hansen, the executive director. And Adele would like to say a few words. So Adele, I'll turn it over to you.
Thank you, Tom. Thank you all so much for attending tonight's presentation. The Trustee Development Committee and the Library Administration, Management and Personnel Committees work so hard to provide programming to help our directors and trustees better serve their libraries. Luckily, this counts towards the number of continuing education hours that you need to satisfy the state's board training requirements. I know that's always a big reason why people do need to sign up, but I think that this is a very important program. It's great to hear about how the lawyers work for the libraries and why it's important to have a lawyer who is separate from your municipality's lawyer. And so with that, I'll turn it over to Dave Hansen. Thank you.
Thanks, Adele, and thank you all for being here. We always start by saying, look, you guys, the trustees, we're so happy that you're giving up of your time to come and learn a little bit more and make your libraries better. We literally, and I always say this, we literally cannot do library without you, and we thank you so much for all that you do for libraries. What you're about to experience, we are a missional organization. One of the big things that Buckles does is shared professional development, and this is the definition of shared professional development. We come together around something that we really want to know a lot more about, get some help, get some direction, get some understanding. And I think understanding is the key for what we're about to experience today, because ladies and gentlemen, we've got two amazing folks, and I just want to take a moment and say, I know you're not going to hear this very often, but I love lawyers. I really do. And it's not just because I'm engaged to one. It's because I actually love lawyers. They are amazing people who do incredible work. And I'm going to tell you right now, as much as I love librarians, and librarians are the reason that libraries exist, we use and depend and rely on the lawyers that support us so much. And so I would just like to say on behalf of all libraries, we love lawyers. All right. And with that, Tom, I'll give it back to you.
Thank you, Dave. And thank you, Adele. Now, without further ado, we would like to get to our presentation of library labor attorneys from A to Z, but we're going to change it up a little bit. Instead of starting with A, we're going to start with Z. So I'd like to turn it over now to Douglas Zucker, who will start off the presentation. Thank you.
Thanks, Tom. I have to say, Dave's comment that he loves lawyers, I've never heard that before. And I'm married for 38 years. I never heard that before. So anyway, it's nice to have all of you join us tonight. We did receive a number of questions up front, so Adam and I are going to talk about the questions and go through them. But certainly, if you have other questions, put them in the chat as he said, and as Tom said, and we'll try to get to as many as we can, if not all of them. The basic question somebody asked, people asked, was, in what situations would you need a labor lawyer? What's the point of having a library labor lawyer as opposed to just a library general counsel? There are a lot of things that a labor lawyer would do, and a lot of areas a labor lawyer would address. If you're in a union environment, obviously you need the labor lawyer because you have to deal with the union. It could be for negotiations of contracts. It could be dealing with grievances and arbitrations. It could be a union organizing drive if you don't have the union in there yet and they're trying to get in, or efforts to stop them from coming in if that's what you want, the approach you want to take. There could be issues arising where you have to go down to PERC. For all those things, you need a labor lawyer. You could also, if you're a civil service library, there's a lot of rules under civil service. As labor lawyers, that's part of the things that we know, and we can help guide you through and do help guide our clients through the processes of civil service, whether it's just the different procedural aspects or whether it's dealing with discipline and removal or defending against allegations that these things were done inappropriately. All of those things require a labor lawyer, or certainly one who knows what he or she is doing. There are also a lot of general, because not every library obviously is unionized, and not every library has civil service. Many of you don't have either. There's a lot of other areas. You have personnel policies because every library has employees. That's how you function. And labor attorneys help with all aspects of the employer-employee relationship. So whether it's developing policies or dealing with issues, we're covering things like discrimination or harassment issues or complaints. We're working on discipline or discharge issues, on leave of absence questions, reasonable accommodation questions, salary and benefits questions. It could be OSHA questions having to do with safety. It could even be things like hiring and evaluating of a director. I've had it where I help in terms of writing the job description for the director. I've even been involved in the interviews with the director because, in my role as labor attorney, because I have that kind of experience, and we would have that kind of experience to help to evaluate. We're not making any decisions in any of these areas. We're just providing guidance in a lot of different areas. Adam, is there anything I missed?
No, I think that's it. I mean, if you also, I'm sure you have dealt with it, wage and hour issues, what we have to pay for minimum wage for an adult versus potentially a part-timer who's a student, a much younger, who's a minor who could potentially be getting paid an hourly wage much less than an adult who is not a minor. Things like that is something else that could actually come into play.
All right.
So, do you want me to just move on to the next one? Is that
Why
how
don't
I'll
you?
do this? So
Sure.
one of the next questions we received is, when does the library need its own attorney? Can I just get the town's attorney? Well, I'll go with Dave Hansen's first answer, which is, since he loves attorneys, everyone should just have one at all times. But one of the ways that you guys should not be utilizing the town's attorney, and I have two sort of good examples with libraries that I've worked with and I'm currently working on now. I'm not going to say names, obviously, but I have a situation going on right now where I have a library who is civil service, and they have, obviously, in a civil service jurisdiction, an appointing authority. And that is the person who is handling the hiring and the promotions and the discipline of employees within the library. Well, I don't know if most of you know, but the library statutorily has the power as the board to hire, fire, and set salary. Well, in this case, I have a town who's making those decisions, right? Who's making the decisions to hire, making the decisions to fire, making the decisions of what the salaries should be, making the decisions of promotions, but they shouldn't be. That should be with my board. So how are we going to hire a labor attorney from a town when the town is telling them, oh, you don't have any of these powers, we do all of this for you? So that's like sort of a prime example of why you should have your own attorney, to make sure that if there's competing interests between the parties, there's two attorneys who are giving proper representation to each client. Another situation that I have going on right now is I had a town with a library with a union. And the library was never negotiating the union contract. The town told the library, oh, your employees are part of this union and we are negotiating the salaries and the benefits for these employees. And this has been going on for years. Little did the library know that their employees should not be part of the town's union. As everybody should know, the library is an autonomous agency separate from the town. We can't have our library employees over in the town's union contract and the town negotiating on the library's behalf. Again, if the library had a labor attorney at the time, the board would have been told, hey guys, this isn't allowed, you make these decisions, the town shouldn't be negotiating these things for you. So, Doug, anything else you want to add?
Well, actually, I had a couple of other thoughts on exactly the issue that sorry, Adam, I don't know where that came from, that Adam was last mentioning. Two different situations that I could think of where the town was doing the negotiating. And in one case, it was there were two different contracts, but the town did all the negotiations. And what ended up happening is the town had resolved all the issues relative to the library employees, but they hadn't resolved it as to like the public works or something department of the municipality. And because of that, they had not finalized the whole negotiation. So the library employees had to wait a year before the contract was finalized, even though it should have been finalized a year earlier, because all the terms were agreed for those employees. But because they were all being negotiated all together under the municipality, it delayed it and caused a lot of issues. There was actually even picketing outside the library, and the library board brought me in and said, we don't want this to happen anymore. We're going to negotiate our own contracts so that we have control over it. And since then, things have been going much better. Another situation where it was similar to what Adam described, where the library employees were part of the same bargaining unit, so under the same contract as the municipal employees. And when they introduced Sunday hours, well, in a library, Sunday hours are not so unusual, but in the municipality, that was an unusual thing. They don't generally work on Sundays. So for them, Sunday hours had to be at time and a half because, of course, that was overtime. It creates a problem now for the library because the library since then has separated, but they're still stuck with the language from the old contract that has provisions that don't really apply to it, including being stuck with this overtime on Sunday, where if they could have, they would have not necessarily negotiated that way. You could have maybe negotiated Sunday as a regular workday. And I've seen other situations where the library is burdened by language in the contract that was really from the municipality first, because they negotiated it. One other situation that came to mind is I know of a library that was under civil service, but they were under the appointing authority, even though there was a separate appointing authority for the library. They were all really being categorized under the municipalities as the appointing authority. So they were doing all of the things that Adam said that they can be doing, all the hiring and firing. And we actually had to have them move, the employees moved from the appointing authority of the municipality back to the library so that the library board could be in control. Anyway, that leads us to our next question, was about what arguments could help convince trustees that a labor attorney is needed. And the question went on to say that some of our trustees prefer to deal with employee problems as matters among family. Were quite annoyed when an attorney was consulted about an issue. Treating employees like family is nice in theory and a very bad idea in practice. Library trustees have a fiduciary duty to do what's in the best interest of the library, to protect the library and to protect the library's funds and use them responsibly. If you're treating employees like family and not working with a professional, like a labor attorney, you run the risk of making serious mistakes, which could create liability for the library and for the library board and expenses. It's not going to create exposure for the library trustees individually because you are protected under the law, so you can't be held individually liable, but the library itself could be. And if you get a discrimination claim and they want to handle it like family by sitting calmly and talking to somebody, as opposed to addressing it by proper steps that a professional labor attorney would follow, you're just exposing yourself to really potentially serious liability for the library. You're also not generally creating the best circumstance for employees, because by having somebody who's more objective and can look at it in the big picture, and particularly, at least for the two of us, we represent a bunch of libraries, and so we see it across the spectrum. So the issues are not unique to one specific library, versus an individual board is usually dealing just with their own library board. So the reasons to do it are primarily a liability issue and protection of liability and avoidance of liability issue consistent with the fiduciary duty. The idea is that we enhance decision-making. We don't replace decision-making. The board is and the director is still making all the decisions. We're just giving them more information with which on which to base that decision.
Yeah, so if I can just quickly add to that, I think that it's great that the board obviously wants to be involved, but there's two things that come to mind to me about an issue. Is first, say there is a union and there is a grievance. A lot of the times the boards aren't always familiar with certain contractual language. So you guys could essentially be reading something and thinking it means one thing, and then telling them that, yeah, we agree with you, and then find out whatever you just agreed with them just cost you, double time or time and a half that you're not going to have to pay forever. Where if you had an attorney potentially reviewing the contract and reviewing the language, they could tell you, oh no, this means the opposite of what you were thinking right now. You should not be agreeing to this. This is going to cost you money, or this is going to have some sort of negative result. Another thing is, for purposes of unions, is negotiations. One thing I always tell my library boards is stay away from negotiations. You don't want to have any sort of negative impact on your employees. Let me, the person getting paid to be the bad guy, be the bad guy. Let them hate me, and I can just be the conduit to provide information to my board. I don't want my board to not be liked by their employees, and it's so much better when you leave the lawyer at the table, I think, rather than bringing in the board, because then obviously there's always some sort of strife between the employees. I think those are two additional reasons that we can add right there.
Great.
The next one is, what is the most common reason for a library to use a library attorney? For me, the two most common phone calls, that's what I'll go off of. The generally two most common phone calls that I receive from my libraries are discipline. Adam, we have this person we need to get rid of. They're really bad. They're not doing their job. Or the second one that I would get would be something about leave time. We have Adam, we have a librarian who's pregnant. I don't know what to do. Or Adam, we have a person who hurt themselves. I don't know what to do. You know, those are things that definitely come into play that a lot of the times either the library directors don't know for sure what to do, or they don't know the law, and there's nothing wrong with that, and that's why we're here to help you. For instance, with discipline, you know, I'll get these frantic phone calls, like I said, oh my God, I don't know what to do, I'm freaking out, we need to get rid of this person, they're lazy, they don't do their job. They do everything wrong, and then the first thing I'll say is, okay, have you ever actually even sat down with this employee and tried to counsel them or give them anything in writing explaining what they're doing wrong? And then the answer is usually no. And I'm like, okay, I'm like, well, we need to start first with addressing the issue with the employee and seeing, are they able to fix these problems? And if not, we can then move through the process of potentially removing them at that point. That's definitely like a very common thing for me. Doug, is there anything for you? Like, what are your top 2 phone calls? Probably would be the most common reasons.
Actually, I would just say the same thing, discipline and leave related questions.
Right.
You know, obviously, if there's union involved, there could be some other things, or civil service questions come up a lot, but discipline and leave issues, whether it's accommodations or medical leave or family leave, and understanding how the laws interact and how the laws apply. There are a lot of lawyers who don't really understand the difference and the interaction or interrelationship between the Family Medical Leave Act, the New Jersey Family Leave Act, the New Jersey Family Leave Insurance Law, and say temporary disability insurance or workers' comp. And you put all that together, and we can sort it all out because we deal with this all the time and we studied it, we understand it. It's a very common problem that comes up, and we can help guide through. In discipline, it's a matter of documentation is key. So Adam certainly said about talking to the employee. It's also about documentation, because I'll always say, even if we ask the question, well, have you had conversations? Yeah, we had conversations. Well, is it documented anywhere? If it's not written down, it didn't happen. And so I help through documentation, and people draft stuff and send it to me, and I help to revise it, or refine it, not because I'm correcting their grammar, but because I want to make sure that it's as clearly stated as possible to avoid ambiguity, make it as strong a statement as possible. That's where their statement. I'm not changing any of the facts or anything they said. I'm just helping them to state it in a way that's clearer and is going to be more defensible if it comes down to that down the road, but we have to defend the position. A follow-up question to that we received was what is an uncommon reason that a library might think to happen to them, but you've seen happen seemingly, and why you would need a labor attorney? I thought about this, and then it came to me. I had a situation that arose not long ago, and the library director called me because they had a problem with a contractor. And the problem involved some construction that the contractor was doing, and doing very poorly. And there were a lot of issues associated with this, and we spent a lot of time focusing on that, which has nothing to do with labor, of course. But what happened as a result of the way the contractor was doing the work they did is they created a lot of dust in the air. And so that created issues like workers' comp, because employees are complaining that they couldn't breathe, or it was impacting their breathing and their airways. There are implications for POSHA, which is the Public Employees Occupational Safety and Health. There were ADA and reasonable accommodation issues where people claimed to have disabilities, and they needed certain accommodations to be able to work in this dust-infested environment. As that's their terminology, not mine. It really was fine, but there were issues related to medical leaves of absence. There were issues related to employees having to be disciplined because they refused to work, or because they were creating issues or spreading rumors about things that weren't valid and weren't true. The point is, it started off as something that was just an issue involving a construction contract or renovation contract. And there were all of these other issues that arose separately and as part of it, all related to employees. And so fortunately they had me, and who could do both. And so I was able to guide them through the employment issues as labor counsel, in addition doing the stuff as general counsel. And I don't think looking at it initially, they would have thought there are going to be all these labor issues that kind of came up, but it's certainly what arose. Adam?
Yeah, I actually had something like so similar, it's scary. I had a library doing construction and similar, there obviously was dust and dirt and everyone complaining that they either can't breathe or they need an accommodation. And it actually got to a point that one employee themselves actually took some of the construction materials that were removed from the building and brought it to an environmental testing facility and then was testing it to see if it had asbestos in it, which obviously then the entire place blew up. You can just imagine all the employees being told, oh, hey, I brought this to an environmental testing place and it has asbestos in it. What do I know about asbestos? Literally nothing. So I then myself am like freaking out that I have to now become this asbestos expert and then figure out what do we have to do for the employees. It's not really just about whether or not we have asbestos, but what do we have to now do for the employees? Thankfully, I learned through this process that if there's a certain percent of asbestos, as long as you're under that certain percentage, it's actually not deemed to actually have asbestos in it that would affect anybody, but it definitely turned into the same thing that Doug was talking about, giving people leave time, closing actually the library down because the state came in to inspect everything and wanted it shut down, figuring out who do we have to pay? Do we have to keep the full-timers on pay? Do we have to keep the part-timers on pay? Can we help the part-timers with getting unemployment to substitute, you know, the fact that they weren't going to get paid at that time? Is there additional accommodations we need to give? Is there ways to figure out splitting up the library, making it safe for certain people to come in and work and certain people not? So it's kind of crazy that this, I never thought that something so crazy that I dealt with would actually be something that you also dealt with, Doug, that it clearly happens in multiple places.
I actually had the exact same situation happen. I have a feeling though we share a client, I believe, where Adam is labor counsel and I'm general counsel, and it has to be because the facts are exactly the same as as you're saying it, not the one I was describing first, but what I was thinking.
Yes.
But and but that also led me to think of something else, and hopefully this will never be an issue for any of us again. But COVID was a huge area where there were a lot of issues that came up involving the library being open and being closed and all kinds of issues. And if you were a trustee during COVID, I'm sure you remember a lot of decisions had to be made about things. But there were operational issues and issues dealing with safety and for patrons and delivery of services for patrons. But there are also a ton of employee-related issues, again, related to employee safety, related to employee scheduling, to the PPE you had to have in place so that the employees would be protected and what kind of equipment you needed. And not only distancing to make sure that patrons were 6 feet apart, but also the positioning of desks and getting all of the protective plexiglass dividers up and everything. There were a huge number of employee issues that came up under COVID. While we're dealing with COVID itself is not necessarily employee related, but it certainly begot a whole lot of labor related issues.
Let's see. The next one was I don't even know how to answer this one, but I guess we can talk about it. Due to budgetary constraints, how can a library afford hiring of a labor attorney?
You want me to start? I have a
to
thought.
the town for money to start.
Well, what I was thinking, I had a couple of thoughts about this. One is people may think that if they're hiring labor counsel that you have to hire them on a retainer where you're paying them every month. I don't know how Adam works, but I'm going to guess it's similar to the way I do. When I get hired by a library, they don't pay me like a fixed amount every month. I just bill them for whatever time I spend, and hopefully they pay me, but generally speaking, they're paying me. The point is there's not a guaranteed cost. They're only contacting me when they need me. And so if a month or 2 or 3, or 6 goes by and they don't have a need for me, they don't call me, it's not costing them anything. But in that 6 months or in that 7th month, when the issue comes up, they have somebody available, and then they pick up the phone, they can call me, and then I'm there and I'm available to help. So I think part of it is it's not nearly as expensive as you might imagine, because it's pay as you go. And if it's pay as you go, you control the expenses by the frequency of use. And if you use them when you need it, and not, you don't have to worry about spending money when it's not needed. There's also a savings that you can't only look at it as the money going out, because if we do our jobs right, we're helping the library to save money as well by avoiding liability. If you go through the proper steps to terminate somebody, there's less likelihood that you're going to have to get hit with some kind of back pay or even maybe having to defend things. If everything is done properly, people are less inclined to maybe have to bring a claim back against you. The point is, if we're giving good advice, we help to save money. And I don't know that you can necessarily calculate what that would be, but there certainly is a savings by expenses you're not incurring, and you can control the expenses by the amount of usage.
Yeah, so same thing here is I obviously only get paid by hour, and I'm very famous for telling my clients it's a good thing if I don't hear from you. Because it means there's no problems and there's no bills for both of us. So I don't have the problem, they're not paying the bill. Another thing obviously is there's definitely savings out there. I could probably bet that if I read the employee handbooks for most of the libraries, there's probably things that we can find that you guys are doing in there that we can find savings. One really easy example is sick time. A lot of people will pay their employees when they resign any accumulated sick time that they want. But actually under the law, if you were hired after May 21st, 2010, your library cannot pay sick time to you unless you actually retire. So that's one savings immediately that we can potentially find you to help pay the cost for me to actually read the handbook. So that's one thing. So the next one, Doug, is about civil service, I believe.
Yes.
Can I promote a more worthy person over a senior person? If yes, what must I do to make it justified? So for purposes of civil service, they have very specific rules for purposes of promotion. If it is a competitive classified title, there's usually a test done. That test could either be written, or the employer can request a waiver where they do, I believe it's like a resume review of the employee, and they'll then give you a list. And the list is going to be the list of the employees that applied for that promotion based off of the score that they got either on the test or on their review. And then there is specific rules that you have to follow for purposes of who to pick. They have something called the rule of 3, which means that you're allowed to pick one of the top 3 people in that list. So as long as they're within the first top 3, there's not generally really an issue as to whether that person is more worthy or more senior. It's, who is the most best person for the job. If they're not within the first 3, that's where there could be potential tricky ways to try to figure out how are we going to get somebody who's not in the top 3. And there's definitely sometimes tricks around it. I do deal with someone at civil service who can also always provides help. His name is obviously I'm gonna not know it off the top of my head when I need it. Something Cohen is his last name, I want to say. And he's always there helping me also to help provide ways of potentially removing people from certain lists to help move people up from the bottom to the top. Is there anything that you wanted to add, Doug, on that?
Yeah, I've had it where we've been able to essentially limit who even was applying, where, first of all, if it's not a competitive position, then, so entry level positions, like I believe a basic library assistant position is non-competitive, where you can hire whoever you want, put whoever you want in. Of course, that's not really a promotion situation, which was the question, because it's an entry level job. But we had a situation in one place where there were 3 librarians and plus the director, and the director left, and then the board wanted to promote the least senior of the 3. And we presented the qualifications of that candidate, and we worked it through civil service, where the others were given the opportunity to apply. They never did. And ultimately, we were able to put in the least senior person, who the board determined was the most qualified, even though she was the newest to the library as a librarian. And she became the director and is doing a great job. So there are ways, there are ways around it. There are the next 2 questions were pretty straightforward, simple questions. One was, at what point must I pay overtime to an employee? And simply stated, the law says you have to pay overtime, which is 1.5 times the base hourly rate, so time and a half, after 40 hours in a work week. Unless you have a policy or a contract that says something different, that's when you have to pay overtime. You don't have to pay overtime on holidays or on Sundays or any other time, unless you have a contract or a policy that says that you do. I'm not sure there's much really to add to that, Adam.
No, it's pretty straightforward, and I think the next one is going to be as well, which is, what is the most number of hours can an employee work and still be considered part-time? So again, another straightforward answer on that is, under the Affordable Care Act, all employers have to provide and make people eligible for health benefits if they're working 30 or more hours on average per week. So essentially, if you want that person to be deemed part-time, they should be working less than 30 hours. That's how I would utilize a base number.
I agree. I have nothing to add to that one either.
Yeah, those were the easy ones.
The final question that we had up front, and so as I'm approaching the final question that we had in advance, I haven't seen any questions coming up in the chat. So if any of you have any questions, please put it in the chat, and we'd be happy to address it, because we have plenty of time. The last question we got in advance was, in an organization with no union and no labor agreement, many of the benefits are outlined in a personnel manual. Can the board freely change benefits such as holidays or number of personal days as outlined in the personnel manual, or does a manual function as a contract, and do changes have to be negotiated? The only time you have to negotiate is if your employees are unionized. If they're not unionized, then you don't have to negotiate with them. If you have a handbook, and one of the reasons why you need to have a labor attorney is because if you have what's called a disclaimer at the front of the handbook, it has to be clear and prominent. And basically it says that this is not a contract, and the employer has the right to change any terms and conditions and benefits and anything that's listed in the contract. Let me say that over. Anything that's listed in the manual without consulting with employees. By having that an appropriate disclaimer, that means that the employer can make whatever, in this case, the board can make whatever changes you want to make. You inform the employees, but you don't need to negotiate with anybody. You don't need to ask them in advance. You just tell them after the fact, after you make the decision. And I mean, I just coincidentally on Friday, I was in court arguing a motion before a judge, and this was the issue about whether an employee handbook in that case, but same thing, constituted a contract, and whether the employer breached the contract. And I explained to the judge that there was a employee handbook disclaimer, and the disclaimer was clear and prominent as the law required, and therefore there's no contract, and the judge agreed with me, and so the handbook would not be a contract, so they could make all those changes. Adam?
Yeah, I mean, I think you pretty much answered it, but obviously in general, everyone should be looking at their handbooks and making sure they are up to date. And obviously, if you do have an attorney, be utilizing them to make sure that they are reviewing them, because they are extremely important for the library, not just setting forth your benefits, but also for purposes of liability, for like harassment, discrimination, hostile work environment, making sure that you have the proper policies there regarding those matters, making sure that there's an investigation procedure on harassment, discrimination, and hostile work environment. Although it's usually a very long, boring document that if you have any trouble sleeping, you should be reading it. It's also an extremely, extremely important document for the library to have.
Okay, so a couple of people responded to our request for questions. I'm going to just clarify one that Adam answered in the chat, but in case everyone's not looking, when I said it was overtime after 40 hours, the question was, did I say 40 or 48? No, it's overtime after 40 hours in a work week. That's when you have to pay overtime hours in addition to that. The second question that came up is, can you talk more about general counsel versus labor law or labor counsel? Can a general counsel do both? Is it common for a library to have both general and labor lawyer? In my experience, and I'll see what Adam says after, for almost every one of my libraries, I am both. I serve at both roles. I am the library attorney because I do all of the library general, library law issues that come up, and public contracting issues, and First Amendment issues, and book ban issues, and dealing finance issues, and dealing with the municipality issues, as well as all of the labor and employment issues that we've been talking about. I think if you can find an attorney who can do both, there's an advantage to the board, because like the scenarios that Adam and I each described, where things come up and somebody who's not familiar with if a labor lawyer is not familiar with library law, there could be misunderstandings and mistakes made, because libraries are not governed exactly the same way as a municipality. And again, I'll point to things that Adam said earlier about who makes the decisions about employees. If you have a general counsel who also understands labor and do labor counsel, that person can cover both of the issues, or really all of the issues on all sides. There are some libraries that have separate labor and general counsel, and I anticipate that works for them. I think of my libraries, I can only think of one where I'm general counsel and they have a separate labor counsel, for whatever reason. But in my experience, most of it is done together. I think it's also a good idea because I think it's more cost effective, because instead of having to call two different people, I'd be on the phone with the director and we could be talking about 3 employment issues, and then we're talking about a contracting issue or about a shared services agreement that we're negotiating with the municipality. And it's one conversation, talking to one person. It's more efficient, and it also gives us the big picture, because you're involved in all the pieces of things. You know pretty much everything that's going on. And libraries, most libraries are not so big that it's overwhelming. But I can tell you, I represent a county library system and has 10 branch libraries. So that's something that's on the bigger side, and it's still something that's within the ability of an individual. Not that I don't have help from other lawyers in my office, but it's something that just has a general counsel as the primary to do both labor and general. Adam, I don't know your experience, hopefully is the same.
Yeah, mine would also be the same, that I generally do general counsel work, and then I also do the labor work as well. In some places, I happen to be labor counsel, but I'm basically treated like a general counsel, so kind of merged over. But Same thing as I could obviously be on the call with the director and be talking about some sort of disciplinary issue or salary issue, and then be talking about a bid project or some sort of construction project that the library is looking to do. And I think it's actually important to have potentially one person doing both, because you really do understand more the inner workings of how that specific library works and how those board members individually work as well.
Yeah, and it's also important for issue spotting, meaning to be able to pick up on different issues. We talked about that earlier with the things I said about the construction project and what Adam said about the asbestos. By being involved in all aspects, it gives you an understanding. Understanding how operations work sometimes impacts how we negotiate a contract with the union, or how it is that we're addressing some other discipline issue, or how we're drafting a policy because we have to be mindful of this impact or that impact. One big area that I spend a lot of time on has to do with finances, and understanding them and making sure that the municipality is providing the full benefit of finances that the library is supposed to get, basically that you're getting your full third of the mill, if not more, and that the library board has control over how that money is spent. Clearly, that's what the law says, very expressly, that the township or municipality cannot spend any of the library tax money except as authorized by the library board of trustees. That doesn't always happen that way. And so understanding the implications of that, and sometimes we're negotiating shared services agreements with the municipalities. So those are covering a lot of different pieces. It could be different services that the municipality is providing for the library. By understanding the implications from an employment perspective, as well as the larger library perspective, it gives you the big picture to incorporate everything into a single document and a single negotiation.
So there's a new question in here, Doug, which is actually on point, which I think you were just explaining. If you want to go into it again, about disclaimers, can you indicate what constitutes a valid disclaimer for employee handbook? Does this apply to policies?
Okay, let me preface what I'm about to say by saying this is not legal advice that we're giving. This is just a presentation. So Stacy, I'm not giving you legal advice when I answer your question. But what the law says is a valid disclaimer. It has to be clear and prominent. Prominent means it has to be positioned in a place where it's going to be readily recognized by employees. Clear has to do with the language and the wording of the disclaimer, that it says that it doesn't create an employment contract between the employer and the employee, between the library or library board and the employees, that the employer has the right to make any changes to any of the terms of the contract, to any benefits in the contract, at any time and without having to consult with anybody. The employer has the right to terminate employees at will. Now, in a union, if they're unionized, that doesn't apply, but that's still part of the language that would go into the disclaimer. Does it apply to policies? Policies are put that are part of a manual. A handbook is basically just a series of policies, whether it's a handbook that sometimes summarizes the policies versus a policy manual, which has the full policy. You have a disclaimer for each of them. It's the same kind of disclaimer. And you need one for the whole document. You don't need one for each individual policy. Hopefully, Stacey, that answered it. Here's a question. Is it critical to have an attorney involved when attorneys are bad mouthing other attorneys to employees regarding board decisions?
Trustees are.
I'll let you answer that one, Adam.
I think that sometimes in these situations we're trying to act as Switzerland, and unfortunately we have to intertwine ourselves to try to speak to these trustees separately to really get the proper point across as to why each one are either bad mouthing or what is the issue and how can we resolve it. I don't believe it's really part of our job as a labor attorney to be involved in the quote unquote politics of the library trustees, but I've definitely been in situations where I'm trying to get two trustees who are butting heads on the same path. So
Yeah, I also have had situations where the board was dysfunctional because there was a split between some members favored one approach and some members favored a different approach. And I had to come in and be a mediator and a psychologist. And I don't know if I had to be a lawyer necessarily, but it's a little bit of all of it to try to help bring them together and find common ground so that they could move forward things. And you know, it worked to some degree. Part of what also will work will be attrition when over time, hopefully people get off the board and we get people on the board who are more like-minded with each other. But certainly it's something that because you have the attorney coming in, and if you have experienced attorneys like you have with Adam and I, where we've been around it, we have some exposure and some familiarity with how things work and how people work maybe. And we can use those skills to try to help the board, but it's not specifically a lawyer who would have to do that. In theory, you could bring in some outside consultant to do it. That doesn't always. It's easier to sell that you're bringing in your lawyer than it is that you're bringing in an outside consultant to help with the board in terms of their functioning. But so I don't know if it's critical, but I think it certainly could be helpful to have a lawyer do it. And obviously, both Adam and I have had experiences where we've been able to be helpful to boards.
yeah, it's definitely a tough issue. Sometimes it's like you want to go home and just, you know, drink away after that. Oh.
Or sometimes you want to drink there, but you know.
that you just want to offer everyone a shot. Start some community.
Are there any other questions? Tom?
It looks. Oh. We gotta thank you.
You're welcome. There he is.
Yeah, does anyone have anything else? Obviously, I thought everything was wonderful. You gave us great answers to the questions that were asked, and I'm
Up here,
hoping that people are not being overly shy. If they have something they'd like to ask or some burning question, we still have time if you'd like to ask.
So here's one from Stacy. How frequently do you attend executive meetings? And for me, that really depends on the library. I have one library who is super formal and makes me come to actually their monthly meeting that I sit through every single month. And then there's some that I never see ever, and they just call me on the telephone whenever there's a problem, or I get an email. And then there's the other situations where I go because there's going to be a closed session meeting where we have to talk about some sort of confidential matter, you know, potentially regarding discipline or layoffs or things like that. So, or negotiations. So it really depends on the library, but there's definitely one that is super formal, that it's a new client of mine, and it's kind of interesting that I go to every meeting and I get to see everything that occurs every month. So
Yeah, I actually have 4 or 5 libraries where I attend their meetings every month. And they want me there because for different reasons, but they generally find it helpful. And usually there's something that comes up where because I'm there, I'm able to answer a question. And invariably, if there's an executive session or a closed session that occurs during the course of the meeting, I'm part of that. In many cases, the reason they're having executive session is some issue where they need the input from council, and that's why they're having us there that's why they're having the session, and therefore I'm attending.
Mhm.
I've never been at a board meeting where I was excluded from the executive session. So it's usually because they want and need my input.
Thank you.
Yeah, and sometimes we're even going, and I'm sure you've had this too, Doug, we're going because either the library director wants us to drop a line or a hint to the board of trustees, or there's a board of trustee who wants us to drop a hint to everybody else in the room.
Right. In many cases, I'm working not only with the director, but also with the president of the board. And when
Right.
there's a strong president, and in many cases, they want exactly to help to educate or to help the board work through an issue, or to understand all the implications of an issue, and the consequences, or how best to address the situation. And if there are exceptions which allow for the executive session or a closed non-public session. And if it's something that requires consultation with the attorney under the attorney-client privilege, that fits with one of the exceptions. And so I would say, where I'm attending, and I also have the same breakdown that Adam does, where I have other libraries where I attend sometimes if they need me, and other libraries where I've never met the board and only met the director on the phone and through email, maybe a Zoom. And sometimes they show up at NGLA and they say hi, and I don't have any idea who they are until I read their name tag and say, oh, I've been talking to you for 4 years. I never met you in person. So,
Looks like I'm
Thank you.
gone, huh? I never got on, but
You.
I'm gonna have to send what's her name a note that I couldn't get on. Cause otherwise I don't get credit.
Yeah, well, you better get another computer or do something.
They just keep.
We've just, just in the process of unmuting everybody, in case you'd rather ask your question verbally, if you have one. We're doing that. Please, if you still want to put one in the chat, that's great. Or if you'd like to ask something in person, Caitlin is taking care of getting everybody unmuted.
you can use the hand to raise a hand. So I think
Yeah.
it seems like people
Yeah.
are so many asking at the same time, but
Or if you want to just unmute yourself, you can go ahead and do that. I see Janice, you had unmuted. Did you have a question?
But it does seem like everybody's been well informed, and everybody, sure, we have no more questions. We certainly still have more time.
Well, if you want, I can actually talk about some topics that would come up for the libraries if you have to stay on beyond a certain time period. That Doug brought up, one thing that we can talk about is leave time with the FMLA and the New Jersey FLA and how it works.
That would actually be great, Adam. I'm actually in that situation right now, so I'd love to hear a little bit about that.
Okay, so, and we can use obviously a pregnant woman who, an employee who is pregnant is going to go out on leave to obviously give birth, and what the heck do we do? So the first thing we're going to do is we're going to ask the employee to provide a note from their doctor regarding what is the expected date of birth. So at least we know that to start with, right? And that can then start with, how are we going to assess how much leave time that person gets? So the first thing is the FMLA. That's a federal program that affords employees 12 weeks of leave from employment unpaid, And they could utilize that for their own serious health injury, to care for somebody else, or to bond with their baby. So for purposes of somebody going out for maternity on this, they would first use the FMLA because it's for themselves. So obviously not everybody works until the day before they give birth. You know, sometimes people take a week off, sometimes people have problems and they'll have to take 6 or 8 weeks off before the actual birth date. So essentially they would go on FMLA for that period of time, right? And they would be using that 12 weeks that's afforded to them during the FMLA. So if I go out 4 weeks before the birth date, I would start my FMLA, get 4 weeks of leave time. And then the great day comes and I give birth to my baby. And essentially after you give birth, there's a disability period, because I'm obviously not a woman, and I haven't given birth, but I have heard that there's a recovery period from giving birth. It's not just like the next day you're totally fine. So there's a presumed period of 4 weeks of recovery. So obviously while you're recovering, that again is still FMLA leave. So I went out 4 weeks before, I'm gonna get 4 weeks after for my FMLA. Once the doctor says, okay, you're officially now recovered, that's when we're going to merge the leave time. And at that point, once you're officially recovered, that's when the bonding period starts with the baby. And once that bonding period starts, the FMLA is now going to merge with the New Jersey family leave, because they're going to be run consecutively together, because you're officially over regarding your injury, and now we're moving over to the baby section. So you're going to get now 12 weeks of leave from the time that you were recovered to bond with your baby, and the remaining 4 weeks from your FMLA is going to run at the same time, giving you now a total of 20 weeks off from work. So realistically, an employee can get 12 weeks for themselves and then 12 weeks to bond with their baby, for a total of 24 weeks off from work, which people don't realize, but it is a possibility. Is there questions regarding that? I know it's kind of confusing.
Yeah, there's one nuance I would say slightly differently. I think for a standard delivery, it's 6 weeks post delivery for recovery, and I'm not basing that. I also have never had a baby, but my wife had 5 of them, so I have some indirect experience with it, but more so from working. And if you participate in state temporary disability, their rule of thumb, it's not official, but it's been their practice forever, is that they will pay temporary disability benefits up to 4 weeks before, or up to 6 weeks after for a pregnancy. If it's a C-section, then it's 8 weeks after. So allowing 8 weeks for recovery. That's not FMLA. That's state temporary disability. But to qualify for that, you have to be medically incapacitated. So the way we've always interpreted it is, if however much time the mother goes out, or the soon-to-be mother goes out prior to delivery, from the time of delivery, while they're collecting temporary disability benefits, the medically incapacitated will count that as medical leave. And then only when that period is over will we start the family leave. Otherwise, it's the same as what Adam said. We just use an objective standard, because if the doctor has to sign off that an employee is medically incapacitated, which is why they can collect temporary disability benefits, not just for pregnancy, for any kind of that's injury or illness that's not work related, and as long as they are medically incapacitated, we'll use that as medical leave, and then the family leave starts thereafter.
Yeah, and one of the things I think that does get confusing is with short-term disability and the state affording it to the employee, outside of giving birth. If you have an employee who gets short-term disability because they have some sort of disability issue, don't assume just because the state is approving them for short-term disability, they now get 6 months off from work. Everyone always needs to remember that short-term disability is just money for the employee's pocket. They also have to get some sort of leave from work, and that's not through short-term disability. That would be through the FMLA that you would take the time off, or through an unpaid leave of absence. Or some other policy that your library has. I know that I have a lot of employers who will tell me, oh, they got short-term disability, so now I just give them off from work for 6 months automatically, but that's actually not how it works.
The other, I agree. The other nuance to this is, whereas short-term disability is providing income for the employee when they're not using their paid time off benefits. So they're not using sick leave, say, or they've exhausted their sick leave, collecting temporary disability while they're on medical leave. When they go to family leave, in New Jersey, at least, we have paid family leave insurance, which pays a percentage of pay. I think it's 80% of pay up to a statutory amount for up to 12 weeks. That's based on both temporary disability and family leave are based on employee contributions. It comes out of their paycheck every pay period. Employers contribute toward temporary disability benefits. Employers do not contribute towards family leave insurance benefits. And so as long as they're on medical leave, they could potentially collect temporary disability. So it's, although the leave part is unpaid, there is a way to pay them. And then if they're on family leave, they can collect family leave insurance benefits.
Yeah, and again, same thing. I have a lot of questions where someone will ask, oh, they want to go on family leave insurance. And again, I say that's not a way to get time off from work. It's just money for the employee's pocket. So just always remember that. And it's not really a determination for the employer to decide, do they get the FLI, the family leave, or the short term. That's really between the state and the employee.
Right. And we should also maybe say that somebody could be on workers' comp and out workers' comp and also be on medical leave under FMLA. They could run concurrently.
Yes. Yes. Is there any topics that anybody was interested in hearing about?
Well, we'll just, unless someone's going to say, all right, we'll just follow the same subject then. One of the other nuances that come with this has to do with reasonable accommodation. And that arises both under New Jersey law as well as under the federal Americans with Disabilities Act. If somebody's out on a medical leave, and depending upon the reason, but generally speaking, if they're out on a medical leave, their medical condition is going to qualify them as being disabled under the ADA. And if they're disabled, they could request a reasonable accommodation, which is some modification to the way of working, which allows the employee to do their job. However, it also would, so that would be, if they're working, it could be a special chair that they need to have because they have a back problem, or they need to have a talking computer because they have a hearing impairment, or they need to have a modified break schedule. So instead of having an hour for lunch and 15 minutes in the morning and 15 minutes in the afternoon, that's a total of an hour and a half, because they have a back problem and they have to be able to stand up. So you break it up and you take that 90 minutes and then they say get 15 minutes every, whatever the math turns out to be, every six times 15, 15-minute breaks, rather than doing it in the course of, breaking it up differently. So it's some modification like that, or some special equipment. But it also could be reasonable accommodation, a modification of your policy. So if your policy says you can only allow people to have up to 12 weeks of leave based on FMLA, and they can come back, not necessarily for pregnancy, but for any medical condition, and they could come back in 14 weeks. One philosophy is, well, the policy says 12 weeks, so 12 weeks you're out. But as a reasonable accommodation, if you have a doctor's note saying that they're going to be out 2 more weeks, but then they'll be cleared to return to work, then as an accommodation, you would extend that leave for an extra 2 weeks. Doesn't have to be paid leave, but you're extending the time so that they can come back to work and resume employment. It's just one way where reasonable accommodation impacts on top of all of these other leave policies. It makes it rather confusing. We deal with this every day, so we understand it, hopefully, I'm sure, because I know I do, and I know what Adam said, so he clearly does. And it just takes even people, if you're not dealing with it often, it gets very confusing, and because there's so many overlapping pieces.
Yeah. the
Which is
reasonable
another reason why it's good to have labor counsel, because we understand it and guide you through it.
Yeah, because the reasonable accommodations for me always come about when somebody's on FMLA and they obviously need that additional leave time. And the courts have obviously found affording someone unpaid leave is also obviously deemed that an additional accommodation you can afford them. So I've definitely had those situations as well.
Sure, absolutely.
Let's see.
One of the other subjects that we touched on earlier, when we said about one of the most common issues, we said leave issues, and then discipline was the other one. So maybe we'll just touch on discipline a little bit. Now, if you're under civil service, the rules are very specific, and there's specific steps you have to follow. And if you're in a union, or not in a union, but you have a union, then there's somebody looking over your shoulder more closely in the form of the union or the shop stewards and the union reps. But the process is basically the same regardless. And that is that you have to make sure, one, that the employee knows what the issues are. If somebody's underperforming or doing something wrong, the basic formula for alerting them, for like a warning memo, is tell them what they did wrong, tell them what's expected they should do right, give them a timetable to improve, and tell them the consequences if they don't. And if your documentation is in writing, and a documentation could be in the form of an email, but it has to be something that's written. Something that's just oral and spoken, as I said earlier, it's the same thing as if it never happened. You need to have a record of it. Emails are good because emails are creating a record at a definitive time. Sometimes we even have to go back because to make note of the fact that there was an oral conversation prior, and so make record of it in writing, in a subsequent writing, for example. So in the writing, we say we discussed it on this date and on this date, and now we're discussing it again on this date. So we have it all in writing now, even if we didn't record it each time we did it. But the importance of having documentation is because if you have to defend against the circumstance, so if somebody's going to sue you or file a grievance against you, or file an appeal through civil service, if you have written documents that lay out the story essentially of what's happened, and that clearly demonstrate that the employee was on notice and put on notice and given the opportunity to correct whatever the issue was, that's how you're going to be able to defend the position and prevail. It also helps because by letting people know what they're doing, you're helping them potentially to improve. There's disciplinary action and there's corrective action. They're really the same thing, but corrective action is a more positive, where you're trying to show them the right way to do it and get them to improve, versus discipline is where you're punishing them, essentially. And if you could use corrective action to educate them as to what would be an appropriate way, that these are the appropriate responses to our expectations, here's what you should be doing in order to be a satisfactory employee. If you can save that person and have them turn from a problem employee to a productive employee, that's much better, because it's much easier than having to fire them and run the risk of what could happen, and then having to go around and hire and train somebody new. If you can rehabilitate an employee as a current employee, that's ideal. And by putting it in writing, you're not only safeguarding if you have to defend it later for discipline, but you're also helping to educate the employee and to give them something in writing so they can refer back to it. Oh, this is what I'm supposed to do. It's a lot of work and it's a pain to do it, I understand that, and most people do not like documenting. In fact, probably nobody likes to do documentation of things in this regard, but it's really very, very necessary. And if you can do it, if you have supervisors, if you have the supervisors doing it, and by doing the documentation, again, you'll have a record to protect yourself, and you'll be benefiting the employee.
Yeah, documentation is definitely key, and being very specific within that documentation. Because obviously, if you do, for say, have a union and a just cause provision, there's different things that you have to worry about. Progressive discipline. Did you discipline that person too harsh too quickly? You know, just depending on the situation, you need to evaluate how bad did somebody do something. Should it be a written reprimand? Should it be minor discipline, which is, you know, any sort of suspension that's 5 days or over, 5 days or under? Should it be a major discipline? Something that's 6 days or more? Should it be termination? You know, a lot of people think that just because they made one mistake, oh, I just want to fire them. And I'm like, we can't do that, because we're going to lose at the end of the day. You may want to, they may be fired, but they're going to be coming back in a couple months from now, and then you're going to be giving them back pay. So like Doug said, it's all about documentation. It's all about being very specific to the employee. And remember, it's not just something that's punitive towards them, it's to change their behavior. It's so that they don't continue this type of behavior in the future.
That also ties into performance evaluations, and if your libraries are doing if they're not doing it, I would encourage them to do it. To have the directors do evaluations of the staff, and as a board, that you do evaluations of your director, and that you do them honestly and accurately. One of the problems we often encounter, I'm sure Adam's experience is the same, but correct me if not, is they want to document about the problems, but then we get the performance evaluation and the supervisor just gave them, you know, all outstandings or all very, very goods or whatever. And the documentation is inconsistent because the supervisor didn't want to get into a confrontation with the employee or whatever. They just went through the motions of doing it because they don't like to do evaluations. But an evaluation can be an important tool in this whole process because it's written documentation. And if it's done accurately, it could be used as the guidance for corrective action by showing the employee, here are the areas you're doing well, but here are the areas where we need to see improvement, and setting goals for the employee in the evaluation. So you're giving them targets to try to achieve, to demonstrate that they're able to perform well. And a director is an employee. And while the director is responsible for ensuring evaluation and implementing discipline and corrective action for all the rest of the library staff, either director or through supervisors, depending on how big your staff is, the library board is who's responsible for evaluating a director. And hopefully not, but there certainly have been occasions where there had to be discipline of directors and discharging of directors. It doesn't happen that often, but it certainly has happened. And you, as the board, you need to do the same kind of documentation. It doesn't have to be the whole board who's working on it. A lot of times, if you have a personnel committee of the board, we often have the personnel committee do the actual evaluation, but getting input from the full board. So everybody has input into the process and input into what the evaluation says, but the meeting with the director to discuss her or his evaluation is just a personnel committee of 2 or 3 people, which is much less intimidating and more productive for a conversation. So encourage performance evaluations being done by your director. I encourage you to do it for your director, and make sure things are well documented going forward.
Yeah, agreed. Just make sure it's well documented. Definitely on evaluations, be very honest and truthful, because there's nothing more frustrating as a labor attorney of someone telling you, oh, they're the worst employee ever, we need to get rid of them. And then we read the evaluations and it says exceeds expectations for the past 10 years. Janice, did you have a question? It looked like you were raising your hand. You're on mute.
You're muted, Janice.
When you have the discipline in writing, does the employee need to sign that?
I'm not I know a lot of places like employees to sign things. I'm not a type of person that needs them to sign off on anything. Cause to me, it doesn't really mean anything that they're signing it in particular. I actually always will tell the library director for themselves to actually write on it, personally served on such and such date upon whomever. Cause them signing it doesn't mean anything, and usually if they do sign some sort of discipline or some sort of a counseling notice or something like that, they usually get very on the defense and be like, well, I don't agree with this, I'm not signing it. And it's like, well, I don't care if you agree with it or you don't agree with it, so don't sign it. As long as there's proof that it's been served upon the employee, for me, that's what's most important.
I have a slightly different view on that. I certainly an employee has the right not to sign it. And if they don't sign it, I agree, I would have the director, supervisor write on it, present it to employee on such and such a date, employee refused to sign. But if you can get the employee to sign it, the advantage is twofold. One, you have a record in their own handwriting that they received it. But it also could be effective in helping them to accept what you're saying and to go forward with it. Many people just get defensive and they're not listening. But if somebody has any interest in really trying to improve and save their job, by having them sign off on it, it gives them a sense of ownership of it. And that it's not just being handed to them, but they're now a part of it because they signed it as well. So first thing all night, but I have a slightly different perspective on this than Adam. And in that I would encourage to try to get employees to sign, never force them, and certainly document it if they don't, by just writing on it that it was presented in the date. But if you could get them to sign, I think it's a good thing to do.
Yeah, I mean, but at the end of the day, there's nothing in law that requires them to sign anything, so
No.
there's not enough much you can do.
Thank you.
You're welcome.
Okay, it looks like we have a couple minutes left. Is there any other last questions?
Will you both be back for the next session?
I
believe
will.
Supposed to be. Unless I get cut after this one session.
No, we will certainly want you back.
It's the sequel. It's going to be bigger, badder, and everything will be more intense.
There you go.
Yes, and
So yes, Adam and I will both be back.
yes.
Okay, thank you, gentlemen. Thank you, everybody, for coming. I do have a couple of administrative things I'd like to mention before we go. Number one, you will be receiving an evaluation if you haven't gotten it already in the invitation. Please complete the evaluations. Obviously the presenters would like to know how they have done, and they certainly have done fine. They have done very well. But more, as importantly, when we ask about what you would like to see in the future, we really want you to give us your opinions of what you'd like to see next. Those of us who've been doing this for a few years really appreciate the fact that you folks want to know more things. You want to have program, and we want to give you programs that make sense to you, that will answer questions for you, that will present you excellent information. So we really take those evaluations quite seriously. Darlene does a great job of gathering them all and totaling them up and making sure that we know as a group what you people want to see and what you people want to hear. So please make sure that you complete those and send them in. Secondly, I only have 3. Secondly, you each will receive an hour and a half credit for your hours, for your board's 7 hours. Those certificates will be emailed to you by the Buckles office in about 2 to 3 weeks. And thirdly, I would like to remind everybody that we will be having the second part of this program. Why you would want or need actually a library attorney separate from your municipal attorney or any other attorney you might want to engage. It's a great program. Mr. Zucker and Mr. Zucker and Mr. Abramson will be back. We will hope that you come to that event. I did have one final thing. This presentation has been recorded, and as soon as it's logical, you will receive the link for that if you wish to view it again, or if you wish to share it with others on your board. So that being said, if there are no other further comments or questions, again, thank you, Doug and Adam, for a wonderful presentation. Thank you all for coming and giving up your time to come and listen to this. And we hope to see you on the 16th. Thank you very much and have a great night.
Thanks, everybody.
Okay.
Great. It was very good.